To my left is Judge Fred Gore. Obviously, we are proceeding via WebEx, and we appreciate Council's cooperation in filing the motion that allowed us to so order WebEx proceedings in this case. For the 2 o'clock session, we have COA 20-657, State v. Ruth out of Forsyth County. I see counsel for both parties, and if ready to proceed, we'll hear from the appellant.
Thank you. Good afternoon. May it please the court. My name is Heidi Reiner. I'm from the Office of the Appellate Defender here representing Mr. Ruth. I would like to reserve 5 minutes for rebuttal. This afternoon, I plan to focus on the first 2 issues in the brief, the Batson claim and the sufficiency statutory construction claim. But I'm, of course, happy to answer any questions the court has about issues 3 and 4 as well. First, turning to Batson. North Carolina appellate courts have issued outright Batson reversal in 1 case ever, and that's State versus Wright. This case is legally indistinguishable from Wright. I know the court is very familiar with the 3 steps of the Batson analysis, but I think it makes sense to go over them just briefly and talk about the parties' burdens at each step. So step 1, the non-striking party has the burden to make a prima facie showing of evidence that supports an inference of discrimination. At step 2, it's the striking party who has the burden, and they must provide a clear, reasonably specific, race-neutral reason or reasons for each and every challenged peremptory strike. Here, the state has conceded that the state did not give a reason for the strike of Juror Quinn. And at step 3, the trial court determines whether the striking party's responses are satisfactory or whether those are pretextual excuses and support a finding of discrimination. So recent decisions from our Supreme Court in State versus Bennett and State versus Hobbs control the remedy in step 1 and step 3 Batson cases. But this is a step 2 Batson case, and Wright controls the outcome in a step 2 Batson case. And here it requires a new trial. In Wright, just like here, the state failed to give any reasons at all for 2 of the 7 challenged peremptory strikes. And this court concluded there that the trial court could not have and did not make findings as to each challenged juror. The same is true here. Here at step 2, the court asked the state to give reasons for the 4 challenged peremptory strikes. The state gave reasons for 2 of the strikes of the jurors, challenged whether one of the jurors was actually Black, and as to Juror Quinn, gave no reason whatsoever, didn't mention her at all during their step 2 discussion. Because this is the step 2 case, this court doesn't have to wade into the difficult waters of a step 1 or a step 3 case. This court doesn't have to look at strike statistics. This court doesn't have to assess attorney credibility. This court doesn't have to rehash the historical use of peremptory strikes in Forsyth County, or even evaluate a comparative juror analysis. The outcome is dictated by Wright and is clear. Just as in Wright, the state here failed to meet its step 2 burden by failing to cite any reason for striking Juror Quinn. The trial court clearly erred because it could not and did not make a finding as to each juror, because there was simply no explanation offered for Juror Quinn.
Can I jump in here and just ask? I think you would agree that under our Batson jurisprudence, particularly post Hobbs, that a trial court's required to make findings of fact at each of those 3 stages. And obviously, I think one interpretation of the record here is that this case was pre-Hobbs, right? It was pre-Hobbs, pre-Bennett, and so the trial court didn't have that guidance. But I wonder if one interpretation of the record here is simply that the trial court just didn't engage on each of the last 2 steps, step 2 or step 3, for that matter. So why wouldn't the remedy here be to give the trial court the opportunity to try and make those findings of fact that would be required at step 2 and step 3, consistent with some of our more recent cases like State v. Alexander and that kind of thing? Is it that the trial court was affirmatively ruling on step 2 of the Batson challenge and then moving past step three, or was the trial court, was this simply sort of a failure to engage because they didn't have the benefit of Hobbs and Bennett?
Your Honor, under State versus Peterson, which predates those cases, as well as State versus Hobbs, which, as you mentioned, postdates them, I think that it is clear that the court did go ahead and engage in steps 2 and 3 here in that, I mean, as you say, insufficiently making fact findings, but they did engage with that because it was the court who specifically asked the state to provide the reasons on the record for the 4 peremptory strikes. And then after receiving rebuttal from defense counsel, all of the arguments specifically asked defense counsel, so are you saying the reason that for these strikes is racially motivated, which is the ultimate determination at step 3? Counsel suggested that yes, that is why I think these strikes happened. And for Juror Quinn, of course, the state didn't give any reason otherwise. The court disagreed and went ahead and let those strikes go forward and impaneled the jury. But, you know, the state here has, in fact, conceded that the prima facie case, step 1, is moot, which I think matters. And they agree that the court did go ahead and engage in steps 2 and 3, and that's what we're looking at here. The state's primary focus is that even though the state has the burden at step 2, there was what the state calls a stipulation as to the reason for the strike of Juror Quinn. Now, there are a few problems with that argument. Obviously, any proffered speculation about the strike of Juror Quinn only came from defense counsel, and that only came from defense counsel after the state had had its opportunity to give a race-neutral reason and failed to do so. So that was in rebuttal that first came out. The other difference is this is not Bennett. Bennett talks about the stipulation to the races of the parties specifically, and the major difference with Bennett is that in Bennett, each of the parties explicitly on the record, so the state and the defense counsel and the court, all acknowledged that these jurors were, at least in their view, African-American jurors. And the fact that they all explicitly stated that on the record is what the court talked about when it found that there was effectively a stipulation. That's not what happened here. The only mention of a reason for the strike of Juror Quinn was speculation by defense counsel during argument. Now, notably, it wasn't a clear and definite statement, which is what is required of the stipulation, because in fact, defense counsel said, look, maybe they struck Juror Quinn because her brother's in jail, but then defense counsel immediately went on to discredit that reason and say, but she also said she has no contact with her brother and that reason just doesn't make sense. Defense counsel was essentially left to fill in the blanks during its argument where the state had not said anything. And if you think about stipulation in this context, if we apply the state's logic sort of to the end, before defense counsel speculated that reason for Quinn's strike, defense counsel first argued that her strike was based on race. The state didn't say anything to that either. So by the state's logic, essentially the state has stipulated to a Batson violation as well. There's no reason, if we're going to imagine that defense counsel's speculation was in fact a stipulation, there's no reason to imagine to count one more than the other. You know, it's important to remember that at step 2, that burden falls exclusively on the state, and the United States Supreme Court has emphasized this over and over. In Miller L., for example, the United States Supreme Court says, when illegitimate grounds like race are an issue, a prosecutor simply has got to state his reason as best he can and stand or fall on the plausibility of the reasons. Obviously, defense counsel can't know what was in the prosecutor's mind. During a Batson inquiry, we're trying to look at the actual reason for the strike. Defense counsel's speculation shouldn't matter. And the United States Supreme Court in Johnson, California versus California has similarly recognized this burden when they talk about the inherent uncertainty present in inquiries of discriminatory purpose counsels against engaging in needless and imperfect speculation when a direct answer can be obtained by asking a simple question. And the court here did ask that simple question. They engaged in step 2 and moved to step 3, and the state just simply failed to give an answer. For those reasons, this case is a step 2 Batson case, Batson error, and governed by this court's decision in Wright, which I will note has been cited very recently approvingly in Hobbs, as well as in Robinson by our Supreme Court. And in Bennett, similar language was used. In Bennett, our Supreme Court explicitly stated that in the event the prosecutor has failed to offer race-neutral reasons For the peremptory challenges in question, it shall order that defendant receive a new trial. That's very recent guidance from our Supreme Court. They understand that this is a different case. This isn't like Hobbs, where it needs to be remanded to give the state an opportunity to respond, proffer its reasons. It's had that opportunity and it failed to do so. This is not like Bennett, where the state in fact did meet its burden at step 2, but then the court needed a chance to do the proper legal analysis. This is just like Wright and should be governed by Wright, and the remedy is reversal, not remand.
I have a question for you, Counselor. There were 4 Batson challenges that were addressed, but there was one where there was some sort of argument about whether or not the person was in fact a member of, was African American. Can you address that? What is your position on that particular issue?
Regarding Juror McGregor, I think that because there was no, I don't think that you can say that there's a stipulation as to her race like there were to the other 3, because unlike the other 3, there was actual a contest on the record. There was disagreement about it on the record. So I think in the absence of actual record evidence of that juror's race, it need not be considered. And I think the briefs don't really argue about Ms. Juror McGregor's strikes. I think it's not necessarily relevant to the analysis here, just because the state still failed to give a reason for Juror Quinn, but the failure to give a reason for Juror McGregor, we haven't challenged here, Your Honor. If there are no additional questions about the Batson issue, I will go ahead and move on to the sufficiency issue. Here, the trial court erred by denying Mr. Ruth's motion to dismiss the charge for firing a weapon into an occupied vehicle that's in operation, because even in the light most favorable to the state, there was no evidence that the car was, quote, in operation, as that phrase should be understood to effectuate the General Assembly's intent here. The evidence, as this court is familiar, showed that the patrol car was left running, but parked and stopped for a traffic stop behind Mr. Ruth's car. The officer testified that he had started to call in the stop, so was in the process of doing sort of paperwork or laptop work when Mr. Ruth exited his car. The way I think this statute should best be, the statute is designed, is that each subsection describes a separate and increasingly serious offense. Under subsection A, a person fires into an occupied vehicle, and that's a Class B felony. Under subsection B, a person fires into an occupied vehicle while that vehicle is in operation, and that's a Class D felony. And then under subsection C, a person fires into a vehicle resulting in serious bodily injury, and that's Class C. Now, before 2005, the statute only covered really the crime described in subsection A, but it was amended in 2005 in response, in part at least, to a shooting that occurred on Interstate 40 of a 5-year-old girl named Rachel Sanchez while she was riding in the car with her grandfather. So that's why this statute, or the amendment, was known as Rachel's Law. The other title for the statute was the Act to Increase the Penalty for Discharging Weapons into Occupied Properties in Certain Circumstances. And here those circumstances are in operation. Now, of course, when we look at a statute, we generally first look at the plain meaning of a statute. But unfortunately, the phrase in operation, there just really is no common plain meaning to it. For example, in common parlance, I feel like this crime is often referred to as discharging a weapon into a moving vehicle. In fact, that is what the judgment in this case says, that he was convicted of discharging a weapon into a moving vehicle, and that's at page 54 of the record. I think you can also think about how people are frequently surprised that they can be charged with a DWI when they're not, in fact, in a moving vehicle. Those sorts of things go to show you that the phrase in operation is not commonly understood by people. So it makes sense for us here to look at the legislative intent behind the statute. This is something that the state doesn't actually address in their brief in this case, the legislative intent of the statute, but in prior cases like State versus Miller, cited in the briefs, the state has previously argued that, quote, in 2005, the General Assembly passed the current version of the statute and added 2 new felonies and articulated the greater harm that exists with shooting into a moving vehicle. That's at page 9 of the state's brief in State versus Miller, which is COA 19-66, which this court can certainly take judicial notice of. But the opinion in Miller similarly recognizes that this is the purpose of the statute. This is why the General Assembly enacted this statute. So in order to effectuate the Assembly's purpose, in operation in this statute must mean something more than a parked running car, which when fired into poses no additional risk beyond firing into a parked non-running car. I think it might be helpful to go through a few examples to show why the state's sort of proposed definition of just a running car is both under-inclusive and can lead to really arbitrary results. So it's under-inclusive in, for example, there are hybrid and electric cars that shut completely off at a stop sign when you're at a complete stop, but still in the course of travel, still traveling. Under the state's definition, it seems like those cars would not be included in the definition of a car in operation. So you can imagine if that type of car was at a stoplight next to a traditional gas car that continues to run at a stop sign, and both of them are fired into, for one of them, you would be charged with the Class D, and one of them, you would be charged with the Class E, even though both of them, because they are able to move, or the driver could be startled, or a tire could blow out, are equally capable of increasing the danger of that crime, of causing an accident in that area. Another example would be a car who is driving down a steep mountain, the engine dies, person's still steering the car, and certainly firing into that car poses a great risk of danger to all the people around and in the car, but because the engine's not running, it may not fall under the state's definition. And then, of course, on the other side, there's over-inclusive hypotheticals, like the facts of this case, but also, for example, if I was going to Target, my husband's with me, but he doesn't want to go into Target. He wants to sit in the car and listen to the radio. We leave it running so the battery doesn't die. There's no reason that if that car is fired into, there's no additional danger created in that situation. The car is.
But given that sort of multitude of examples, and I was thinking of the hypothetical of somebody driving through a carpool line, at a school, where you're starting and stop, those kinds of issues. Doesn't that tend to suggest then whether or not a car is being operated or a vehicle is being operated is more of a fact question that could be argued to the jury as to whether or not the car was in fact being operated or not? And in which case, why then wouldn't we submit that question to the jury and allow the lawyers to argue over whether or not the car was being operated or not?
Your Honor, I think that it is this court's job to interpret this case specifically on the facts of this case. I mean, yes, there are all these hypotheticals, and they're, I think, useful to discuss what a statute means. But here, the simple argument is that there was no evidence that this crime, as it was committed on these facts, posed any increased danger than a crime that's contemplated by subsection A.
Is there any evidence of how long the car had been, the police vehicle had been placed in park?
Not that I'm aware of, Your Honor. I do know that the officer testified he had already begun to call it in, so at least long enough to, I'm not sure how they do that, park the car and get on your radio or on your computer or call. But beyond that, I don't have specifics. But, it was clear that Mr. Ruth had pulled over, a stop had been started. There was enough time for both cars to start, and the officer testified that he had left, a car length of space and gone with his normal practice, and that he just left the car running. The only reason he left it running was so that he didn't run the battery down while running his blue lights. So I think when we're thinking about those examples, it's important to look at the legislative intent, like I said, but if this court is inclined to think that that's a jury question, I think it's important, as discussed in issue 3, the jury wasn't instructed in any way about what an operation means. And as we've discussed, I don't think there is a sort of plain meaning or that people generally know what that means. Had the court or the jury, been properly instructed with a definition of an operation, I don't think that Mr. Ruth would have been convicted of this elevated felony. There are no further questions on that. I can save my time for rebuttal.
I would just ask you one quick question. So your position is that because the vehicle was actually parked, it was not in operation, but would your analysis be the same if the vehicle was stopped at a stoplight or a stop sign?
No, and I think that's why thinking about it as traveling or in the course of travel makes sense. I think because, you know, when you have your foot on a brake at a stoplight, that poses a different risk than if your car is in actual park. So for example, if a car was fired into or a driver was shot, when the car is in park, that really poses no additional danger, increased danger to the people around them. However, if your foot is just on the brake and the car is not in park, you could let your foot off the brake, the tire could blow out, your car could spin out. There's a variety of things that would happen. So I think that in operation should absolutely include cars that are fully stopped at a stoplight, but still in the course of travel and not parked. To me, the key differentiation in this case shouldn't matter whether the car was running, but it's the fact that it's in park and there's no additional danger to the public or increased danger beyond that of firing into a vehicle. The danger is really what should circumscribe the boundaries of the statute, as discussed, as this court discussed in State versus Farabee.
Was there any request made for an instruction, sort of putting definitional parameters around the term in operation?
There was not, and that's why we're in plain error land on the instructional issue.
Counsel, their last statement, I've heard, you know, the hypotheticals, and I can let those go. But I guess being a person who has seen a lot of different things happen when firearms are discharged into different things, is it not also conceivable that a vehicle running with gas in it and, you know, a round hitting the vehicle either in the engine compartment with a fuel line, explosions could happen as well? We talked about other scenarios, so I'm just, what you just said, your last little bit, I just couldn't go without, you know, it sitting there and running and a round hitting something that was either electrical or dealing with fuel. Could that not pose an additional threat to the person that were around or to the public that would be around that vehicle if there was an explosion resulting thereof? I have to put it out there for you.
Sure. I have to admit a little bit of lack of knowledge about the functioning of cars in that respect. But my guess, I guess, or my slightly educated guess would be that that risk is present regardless of whether the car is parked or not. For example, I think if you fired into a full gas tank in a parked car that's not running, you also have the risk of explosion. Like, certainly under subsection A, this is a huge risk. It's never okay to fire into any car, regardless of its status. It's not a risk-free crime, but I think the importance we just have to come back to is that each subsection is elevating that crime based on certain circumstances. And I think in general, certainly under the facts of this case, there were no elevated dangers because that car was in park. And if the court has no further questions, I'll reserve time for rebuttal.
Judge Wood, any further questions?
Not at this time.
Judge Gort, no? Okay. Very well. Thank you, counsel. And if the state's ready, we'll hear from the state.
Thank you, Your Honors. And may it please the court, my name is Justin Eason. I'm an Assistant Attorney General representing the state of North Carolina, the appellee in this case. This case hinges on the question of whether or not the state's burden to provide a race-neutral explanation to the trial court during the Batson inquiry had been satisfied. And Your Honor, we would argue that it was satisfied because the burden was obviated when the defendant stipulated that there was a race-neutral reason and proffered that to the court. So
Where's that stipulation in the record? I mean, where is there an actual stipulation in the record?
There is no statement, Your Honor, that this is a stipulation or anything of that nature. But by the same token, there was no stipulation in Bennett in the same way that it wasn't a proffered as a stipulation and accepted as a stipulation. It was a stipulation by implication, according to the language of State v. Bennett. And in this case, Your Honor, we're dealing with a similar sort of circumstance. The record in this case, Your Honor, is politely put very sparse. The jury voir dire was not recorded. No prospective juror was asked to self-identify as to race. There were no additional follow-up questions from either the attorneys or the court as to the race, even after these objections of Batson were raised. The way in which the Batson objections were raised was done somewhat lackadaisically. There was sometimes it was just the word Batson, other times it was objection, but it wasn't specified to be Batson. The Batson objections were actually raised at the point of challenges for cause rather than peremptory challenges, which, as Your Honors are well aware, challenges for cause are not subject to Batson exclusion. If there's a for cause challenge, that's for cause. And the trial court, when the prosecutor asked the trial court point blank, are you saying that the defendant has made a prima facie showing of a racial animus behind these strikes? The court said no, but then asked them to answer anyways. So the record is very sparse and very muddled at this point, and it's generally incumbent upon the defendant and the appellee, the appellant, when they're putting forward their record for the court to make these considerations, to have preserved these types of factors for the court to consider in their determination.
Counsel, before you go further beyond that and looking at, the transcript, does it not seem compounding the lackadaisical word, using your word, lackadaisical, does it not seem to compound the clarity at which there was compliance with Batson when the court was specifically asked, Your Honor, is this court finding there was a prima facie case? Before we even get to saying that it was moot, the court says no. Well, I'm saying he made an objection. So the court's saying one thing but doing another. So I'm asking you, with that lack of clarity, is there not a need for this court to make some determinations of clarity based upon the trial court saying two different things but then doing something else?
I mean, Your Honor, that is sort of the burden that this court has. That's their obligation, is to come up with some form of clarity. But it may simply be that in this case there isn't. Under certain circumstances, the state could be arguing, Your Honors, that the defendant hasn't provided sufficient evidence of the racial components of the jury for them to even make this type of question. Now, because the judge went ahead.
If that's the case, then why would he go down that rabbit hole?
Your Honor, I can't speculate as to why he would go down that rabbit hole, but only go the part of the way that he did, or in the manner that he did. It seems like there might have been some sort of conscious, or there was some sort of conscientious aspect to this, but I don't know that, Your Honor, I could call it a well done or well conducted inquiry into the Batson, and I don't think anybody would do that. The practice of finding the race of the jurors by stipulation is one of the ways in which the court in Bennett sought to address this type of lack of a record in order to permit appellate courts to have reviews. And the language that they used in Bennett was very, very broad, and it encompassed an enormous number of situations, which, Your Honor, we find ourselves in here. Just as the stipulations relieve the defendant of his burden to present and preserve evidence of the race of the challenged jurors, so too in this case did the stipulations relieve the state of its burden to produce a race-neutral explanation for Juror Quinn. In operation, these were done the exact same way. Everyone just sort of said, yes, okay, we'll continue on with this understanding in mind. No objections were drawn from the judge, no objections were drawn from the state, no objections were drawn from the defendant in any case. Now, the step 2 inquiry of Batson, as counsel has indicated, it's not actually a bifurcated proceeding. It's part of the total offer of evidence from both parties. The language used in Snyder versus Louisiana is, in light of the parties' submissions. So the step 2 inquiry, Your Honor, we would argue is actually, it's the entirety of the inquiry. It involves both what is proffered by the state and what is proffered by the defendant. And in all of the cases which defendant cites for the proposition that we can't consider the defendant's opinion about any particular juror or anything like that, those are all in references to strikes that the defendant made, where the court has said that what the defendant does doesn't have an impact on the state's peremptory challenges. Now, that's not to say that what a defendant stipulates to in court during the process of the second prong of the Batson inquiry cannot be considered by this court or shouldn't be considered.
Mr. Eason, be
Yes,
very clear, please, for us, what you contend was in fact the stipulation.
The stipulation occurred when the defense attorney said, as to Juror Quinn, it appears that there's a race-neutral reason in that her brother is in jail. He then went on to try and rebut the race-neutral reason, but he stipulated to the presence of a race-neutral reason at that time. If there had been...
The fact that he said, I think that the only reason that racially neutral reason would be her brother's in jail, but she has very little contact, as I understand, with her brother, and then goes on and later says they didn't present a racially neutral argument, racially neutral reason for the peremptory challenge immediately thereafter. Wouldn't that, just by the very language that was said by trial counsel, indicate they did not in fact make a stipulation?
Oh, Your Honor, that's in the rebuttal portion where he's saying that they have not done so. That's part of his argument to the court, not necessarily part of his acknowledgement of the facts. I think that he's got a two-part sort of situation where it's his job to convince the court at that second prong that in fact these are pretextual suggestions and that they are not in fact race neutral. So
well, let's be clear, it's only the burden's it's only the defendant's burden. If in fact the state is deemed to have offered race neutral, facially race neutral explanations for their use of that peremptory challenge.
that's correct, Your Honor. And at this point, we're arguing that because they conceded by stipulation that there was such a race neutral reason and then proceeded to argue against it, that they acknowledged, relieved the state of their burden, and then proceeded on with the inquiry.
Would you concede that if at the end of the second step, the trial court looks at the prosecutor and says, do you have, I find there's a prima facie case. Do you have a race neutral explanation for the juror for using your peremptory challenges on the jurors? And the state simply says, no, Your Honor, I'm sorry, we don't. At that point, it's done, right? There's no need to move to the third step to determine whether there was in fact a race neutral explanation. Like the Batson inquiry ends there, and trial court should declare a mistrial, right?
Yes, under those circumstances, Your Honor, I would say that if we're at the end of the first part, the prima facie case, the judge has made the finding of prima facie inquiry, and he then moves to the state, and the state says we cannot meet our burden, then that would be that would obviate the need for a third step of the analysis. So, Your Honors, it's important to remember, I feel, that stipulation is a substitute for proof in both civil and criminal cases. It removes this, it removes a burden. It takes it out of the realm of a fact by formally conceding the existence of that fact. It's binding in the same way that a jury verdict would be. And so, Your Honor, the defendant has argued that under Miller L versus Dretke that substitutions of reasons by a court after the fact can't satisfy a prosecutor's burden, and that's correct. However, we would argue that stipulations at the point of the inquiry, that where it was done in this case, at that second point in the Batson inquiry, are sufficient to relieve the prosecutor of his burden.
Would you concede that the prosecutor did not, in fact, state that Mrs. Quinn's brother was in jail and that came from the defense counsel?
Well,
as being an only possible reason it could be a reason for the challenge?
From the record, we can't show that. Now, whether or not that was elicited on voir dire, by which party, under whose questioning that came out and what was made of it, we can't know. What we can know is that it clearly was stated because it is the defendant admits that it was said, and everyone agrees that she in fact said this. Nobody raises any objections. So, Your Honor, the trial court, the third part of the test involves the question of whether or not, in light of the parties' submissions, the defendant has shown purposeful discrimination. And under these circumstances, Your Honor, we feel that that language in Snyder versus Louisiana helps to sort of undergird the notion that it is actually both of the parties have the ability to volunteer this type of information and make these sort of showings to the court. Now, generally, it's not always in cases like this, there's not always a stipulation, obviously. Sometimes, apparently, there's going to be, and the Supreme Court has acknowledged that in conducting these inquiries, stipulations are going to happen. They may not be explicit stipulations. They may be determined sort of by implication. And under those circumstances, it's appropriate for the court to consider what those stipulations mean and how they remove certain arguments from the realm of the court's decision. So I would also note, Your Honor, that under Hobbs, an appropriate remedy for finding that a Batson inquiry was not appropriately conducted by the court would be a remand for additional findings of fact and conclusions of law. They can, pardon me. If the defendant is alleged that this is clear error and that burden has been met, then it's important to consider that it's a remand for the trial on all charges. As Your Honors are aware, he was not convicted of the attempted murder charge and the assault with a deadly weapon on law enforcement officer. That charge had to be arrested because of the conflicting nature of the two charges. How you could have an assault with an intent to kill and not have an attempted murder, the judge rightly said that that would be a conflict in terms of sentencing, and so he arrested that judgment. But this is a light switch, Your Honor. This is not a dimmer switch. I don't know that the defendant can allege that this jury was sufficiently unconstitutional that it rendered all of his guilty verdicts null, but that his acquittals ought to stand. Either this jury was composed appropriately and constitutionally, or it wasn't. So he's either asking to be retried on attempted murder and and the assault on a law enforcement officer with intent to commit, with intent to kill, or he's asking basically to have his cake and eat it too, to say that, well, you know, this was pretty bad, but the part that they didn't convict him on should stand. It's a binary proceeding, Your Honor. Either this is sufficiently constitutional to render a verdict, or it's nugatory in its entirety, and we're back to square one with the attempted murder charge and the assault on an officer with intent to kill still on the table. If there are no additional questions on the Batson issue, I'd like to move on to the question of inoperation. The second issue before the court is whether or not it's appropriate for the denial of the defendant's motion to dismiss the charge of discharging a firearm into an occupied vehicle was done appropriately. We would note again, for Your Honors, that during the inquiry at the close of all of the evidence, after in both cases the motion had been denied, that the defendant's counsel indicated that he intended to plead guilty or admit or acknowledge that he was in fact guilty to this offense. And the judge conducted the appropriate colloquy with the defendant at that time to determine whether or not that was the case. And he said, yes, Your Honor, we intend to concede guilt on these issues. So clearly, Your Honor, as far as this fact-specific inquiry as to whether or not inoperation was sufficient, at that point, Your Honor, he wasn't making a fact-specific argument, well, park is not operation, driving is operation, or anything like that. This is an entirely new animal where he's trying to argue that he was prejudiced by something that he ultimately did not, like, even though it was denied, he didn't even contest it. He in fact admitted it. And so he's attempting to raise reversible error on those grounds. Now, where the language of a statute is clear, we need not construe the statute and must simply apply the plain meaning of the statute. That's Court of Appeals Myers versus Myers in 2020. The legislative intent becomes very critical when there is ambiguity into the statute. But in this case, the statute is clear and doesn't require any additional inquiry to address the legislative intent. For a vehicle to be in operation, it just has to be capable of being operated. That's the plain meaning of the term. And the jury didn't require any additional instruction on this issue at all. They received no instruction whatsoever. Nobody requested any additional instruction, but the jury was still able to parse out pretty quickly that yes, in fact, this constituted operation as far as they were concerned. Operation is the condition of being active or functioning. And in this case, the officer was still behind the wheel. He had just placed the vehicle into park. The engine was still running, and he was attempting to contact people on his radio. Now, Judge Gore had mentioned that when a firearm is discharged at a vehicle, a lot can go wrong. It's an internal combustion engine. It's tiny controlled explosions is what we're dealing with. That's the very nature of an automobile. Tiny controlled explosions drive the pistons, which operate the engine and give the vehicle the ability to move forward. It's hard to argue with a straight face that discharging a firearm to a vehicle where there are tiny controlled explosions happening at the moment is not inherently more dangerous or less dangerous than if the vehicle was in drive or neutral or reverse. There's nothing in the statute that seems to indicate that the position of the gear shift should in any way impact whether or not a vehicle is being operated for the purpose of this enhanced penalty. There's been a lot made of Rachel's Law, the 5-year-old girl who was struck by a bullet from an overpass on I-40. But Rachel ended up suffering permanent blindness, vision impairment from her injury. And so it isn't just that there was a vehicle traveling, it was also that there was a serious injury that resulted from hers. And so, Your Honor, we can see that as far as what the conduct that the legislature intended to discourage by virtue of these enhanced penalties is the vehicle was in operation and then the substantial injury. And the fact that Rachel's Law involved a substantial injury, I think that doesn't necessarily go to show anything about whether or not the legislature had in specific mind that a vehicle be in motion or traveling. Looking through the legislative history and the drafts of that bill might be productive, but again, that hasn't been suggested that the language that they chose was specific to create a limited range. It appears that it was in certain circumstances a broader range of conduct that they wanted to discourage.
Well, and I think what we're hearing from your colleague, though, is that whatever it is, there has to be some distinction between discharging a weapon into an occupied vehicle and discharging a weapon into an occupied vehicle in operation. And I think, and rightly so, I think we're being asked to determine whether in this case we can draw that line specifically, from the statutory language and whether this case fits, which of those parameters this case fits into.
Absolutely, Your Honor.
So draw that line for me. How would the state have us draw that line?
It would be a fact-specific inquiry of whether or not the vehicle was active and functioning and capable of being operated. That seems like the most common sense. If something is in operation, it's active and capable of being operated. And that would include both of the concerns that they might have about hybrid cars that have a stop-start, that the engine would not necessarily be running, but no one could not argue that it was in fact active and capable of being operated. At the same time, a vehicle with a driver behind the wheel who has just placed the vehicle into park using whatever gear shift mechanism they have, that vehicle is still perfectly capable of being operated. The engine is running. It takes virtually no time to put it into a different gear. And when bullets are flying, Your Honor, that creates a pretty unusual, panicky situation, which, the notion that because it was in park doesn't mean that when the bullets started hitting the hood of the car, the officer couldn't slam it into reverse and try and get away, or accidentally hit something and ram another vehicle, or even drive off the road and injure someone else. The question is it active and is it capable of being operated? And if both of those factors are present, then that's all that's required, Your Honor, for operation.
So, Mr. Eason, under that definition, any vehicle that can be operated, whether it's on or not, could be considered to be an operation.
Well, not necessarily, Your Honor, because it would have to be active and able to be operated. So, for instance, if I were to be a horrible parent and leave my child in the car with the engine off while I ran into the store and someone was to shoot at the vehicle. It's not capable of being operated. If, however, I left the engine running and, you know, they're in the seat, they're not even necessarily in the driver's seat, but just in the car somewhere where they could reach the controls and try and do something, then the vehicle is active and it's capable of being operated. And so that would be the distinction. It's a combination of active and in operation. Your Honor, the plain language is just that. It is plain language. The notion that we would have an inquiry that would be fact specific as to whether or not the car was in drive versus neutral versus reverse is not a fruitful inquiry, or I think anything contemplated by the legislature when they created the statute. And precedent has, in State v. Morrison, this court upheld multiple convictions under subsection B of this statute when multiple shots struck a vehicle that was both stopped and letting people jump into the vehicle to get away from the assault, and also in transit away from the vehicle. This court has held that both of those were sufficient to show that a vehicle was in operation and upheld the conviction on all of those charges. If there are any additional questions, I will take them or I will relinquish my time.
Judge Wood, Judge Gore, any further questions of the state?
I do not have any.
Thank you.
Right. Thank you. We'll hear rebuttal from the appellant.
Your Honors, just briefly, I wanted to talk about the Batson Challenge again. The United States Supreme Court has said that a Batson challenge does not call for a mere exercise in thinking up any rational basis. Here, defense counsel tried to think up any rational basis, and that was in rebuttal. And in response to counsel's argument about Snyder versus Louisiana, certainly the step 3 judgment by the court is one that considers the party's submission. But this is why I wanted to go through the 3-step Batson inquiry at the beginning and talk about the burdens, because both parties, of course, have a burden and both parties make submissions before the court gets to step 3. At step 1, it is the non-striking party's burden. They make out their prima facie case and provide evidence. At step 2, it is the state's burden and exclusively the state's burden. And then at step 3, after the defendant has an opportunity to make rebuttal arguments, the court makes its determination based on those step 1 and step 2 submissions from the parties, which I think is really what the language in Snyder is talking about, because Hobbs, Bennett, all of the United States Supreme Court case law is very clear that it is the state's burden and the state's burden alone at step 2. Here, Judge Gore, addressing your question about how the court really engaged in this process, it is true that the court, the prosecutor asked, Your Honor, is this court finding that there's a prima facie showing? And the court initially says no, and then there's dashes indicating a pause in the transcript, and immediately then walks it back and says, well, I'm saying he made an objection, and I want you to put on the record why you excused those jurors. That is proceeding to step 2 under our appellate court's precedent and the United States Supreme Court precedent. When you move on to step 2 and get those reasons from the state and then make an ultimate determination at step 3, step 1 becomes moot. And we don't even really need to think about what happened at step 3 here, because what matters is that the state failed to meet its burden. And Judge Hampton, you pointed out that when the state fails to meet its burden at step 2, there's really no reason to go to step 3. The court did here, and of course they would have on the other 3 strikes that were challenged, but as to Juror Quinn, there was no need to move forward. The state didn't meet its burden, and that should have been the end of the inquiry there. And of course, if we were at trial and this were happening live, we would have just reinstated Juror Quinn. But now we're on appeal. The only remedy here is an outright reversal and a new trial, because that's the only thing that will fix this issue at this point. And then the last thing I just wanted to touch on a little bit about the statutory construction is that counsel sort of takes issue with the factual inquiry that's required, but then proposes a definition about being active and capable of being operated. And I think, as Judge Wood's question indicated, that also is going to require a pretty active, fact-intense inquiry. And that's just something that we have to do here. But I think when we look at guiding principles of statutory construction, like avoiding redundancy, it's important that we make sure on the facts of each case, subsection A and subsection B mean something different. And the General Assembly has recognized, or this court has recognized in Miller, State versus Miller, that the General Assembly's intent was to provide increasing penalty with each subsection for the increasing danger created by situations. And I just don't think on the facts here, where a car is parked, stationary, no intention of moving in the moment, there is no increased danger, and the motion to dismiss should have been granted. If the court has no questions, that's all I have.
There are no further questions from the panel. We'll thank counsel for their arguments, for their good arguments, and the case will be submitted. And Mr. Sword, we can adjourn this session.
Yes, Your Honor. This session of the North Carolina Court of Appeals is adjourned.